Good evening, everybody, and thank you very much for joining. I can see there's still people coming in to this evening's webinar. I'm delighted to say that we've got somebody from the DVLA here. Dr. Claire Fang is joining us to present to you and to take some questions. My name is Gerard Ross. I'm one of the medical legal advisors. Bit of a Scottish and Celtic theme today. I was a consultant surgeon in Scotland. Dr. Claire Fang from the DVLA was a GP in Scotland, now works for the DVLA. And we've also got in the background, I've not put him on the slide there, Dr. Ed Farnan, who was a senior GP in Northern Ireland before coming to the MDU, not the DVLA. Hopefully that won't happen. We're going to talk to you a little bit about confidentiality of the DVLA. The reason we're talking about this is it's a really common call to our advice line. About half of the files that we get from involving the DVLA and disclosure are questions, difficult questions on disclosure, when to disclose, etc., etc. The other half of the files that we get are complaints about a doctor's decision to disclose information. So it's a difficult and a fraught subject for you, we recognize that, and it obviously is very impactful for patients. So today we're going to talk a little bit about why it's an important role and understand some of the guidance. And I'm not going to talk for long. Claire's going to do the bulk of the talking, you'll be glad to know. So why are we talking about this? Well, these the next few slides are pulled from government statistics, and these are statistics from 2022 showing deaths related to secondary road traffic collisions in the UK up to 2022. And you can see that over the last 30 years, 40 years, there's been a significant decline in deaths, but over the last 10 years, it's fairly plateaued at around about 1,500, 1,700, 1,800 deaths a year on British roads. So in 2022, there were 1,700. There were nearly 30,000 combined killed or seriously injured in the year, and another 136,000 people injured at all levels of severity. And this is just illustrated on this slide here. Within that, and it's no longer pulled out in terms of tables that, or at least in terms of graphs that the government produce. They do have some information about the impact of drivers' health on road traffic collisions. The orange lines are all injuries related to a driver's illness, disability, or mental or physical health problem, and the blue lines are the deaths. And as you can see, there's still between 80 and 120 deaths a year directly related to a driver's illness, and between 1,500 and 2,500 serious or injuries every year from a driver's ill health. Sometimes, though, I do think these things can be a little bit abstract. We're not clearly presenting the issues in terms of harm, and when we're advising doctors on disclosure, we always need to think about the harms that can arise. So that picture is of a driver who withheld their medical history from doctors. You can see that he's being huckled, as we might say in Scotland, by the police there, and that's his solicitor next to him. But this was a tragic story. This driver had a Class 2 license and drove a bin lorry for Glasgow City Council. He suffered an episode of vasovagal syncope at the wheel. And this is the picture of the bin lorry he was driving as it ploughed into a very narrow space between the Millennium Hotel in Glasgow and Glasgow Queen Street Station. This happened about 2:30 in the afternoon on a busy pre-Christmas shopping day. These are the 6 people who lost their lives in that Glasgow bin lorry crash. There were 15 other people who were injured as the bin lorry careered into that space at about 37 miles an hour. Sheriff Beckett, the QC leading the fatal accident inquiry. So for those of you in England and Wales, a fatal accident inquiry is a sort of Scottish coroner's inquiry. They're not as common as coroner's inquiries are, but they serve much the same purpose. Anyway, the QC leading it noted that the patient had not told the whole truth about their symptoms to their doctors. And moreover, that the doctors themselves had failed to advise the patient to notify the DVLA and had failed to inquire as to the details of those symptoms. There were 19 different sheriff's recommendations to lots of different parties, not just doctors, but the first one was to doctors. And it said that doctors generally, and general practitioners in particular, should take steps to ensure that medical notes are made and kept in such a way as to maximize their ability to identify repeated episodes of loss of consciousness, loss or altered awareness in the case of patients who are or may become drivers. And these are the sort of considerations that we think about when we're talking about whether we should release information. As you know, if you're going to release information about a patient, you need to think about their consent, think about whether the disclosure is required by law, and think about whether the disclosure is required in the public interest. And the public interest is what is mentioned in the GMC guidance at paragraph 63 of confidentiality. I'm not going to read out the whole slide, but the important thing here is there can be public interest in disclosing information if the benefits to an individual or society outweigh both the public and the patient's interest in keeping the information confidential. So you'll all be aware of that, but if you need to revise it, we've got lots of stuff on our website to help you for your CPD, so please do have a look. This comes up a great deal, as I've said, on the advice line, so doctors phone us quite a lot. The DVLA publish a document called Assessing Fitness to Drive, a guide for medical professionals that I use on a very regular basis. And the most common situation is obviously when a patient doesn't accept the information being provided by their doctor. Claire's going to talk more about this, but as you know, the driver is legally responsible for informing the DVLA about a condition that may affect their fitness to drive. And as set out in the GMC guidance, the doctor needs to explain to the patient the condition could affect their ability to drive and that they have that legal duty. If the patient won't accept the diagnosis or the effect of the condition, a doctor can suggest a second opinion and try and arrange that for them, advising the patient not to drive in the meantime. And if a patient continues to drive when they may not be fit to do so, you should try and persuade them, and you may, as long as the patient agrees, discuss it with their relatives. But if you don't manage to persuade them to stop driving, or you discover they continue to drive when you've told them not to, you should contact the DVLA immediately. So that's the simple guidance, but obviously it's much more complicated, and we hear the complicated stories regularly. What I'm going to do now is I'm going to pass over to Claire. Welcome, Claire, and thank you very much for doing this with us.
I do apologize, Claire, can I just briefly interrupt just to encourage people to put their questions in as they think of them into the question box in the webinar tool. That gives us a chance to collate them. And hopefully
can I emphasize that as well, to say that there's over 1,000 of you in the webinar. So there will be a lot of questions. So if you make your questions as short as you can, to the point as you can, we'll do our best to address them with you. Claire, I'm going to mute myself and hide my camera and let you crack on. Is that okay?
Absolutely, yeah. So thanks very much, Jared. As you said, I'm Claire Fang. I'm one of the doctors who works for DVLA. At the moment, there's about 40 of us that are in post at the DVLA. That is the main office in Swansea that you're looking at there on a rare sunny day. What I was asked to do today was basically just try and give you an overview of what it is that we do. I'm not always sure that everyone has an understanding of what the doctors at the DVLA do, what we can do for you, what we can do for your patients. So today, what I'm really going to do is give you an overview. The basis for the DVLA's medical standards, some of it might seem a bit dry initially, but I'm really just trying to make to the point to everyone that some things that we do, we are constrained by the legislation that is in force, and some things that we do are based on advice that we get from experts in the field. So I'll try and explain a bit about the difference in that in our standards. Jared, can you move the slide on for me actually? Thank you. I'll explain a bit about what we do in the driver's medical department at DVLA. I'll also go over roles and responsibility. Jared's touched on it already, but we'll go over what is it for the patient to do, what is it for you as our doctor to do, what is it for DVLA to do, and try and give you an idea of where the roles and responsibilities lie. Then I'll move on to what's possibly more interesting or constructive, is to give you a few case examples. I've picked drivers with example of two of the very regular recurrent themes that we would get on a very regular basis through the DVLA, but also cases that we get a lot of questions from healthcare professionals about, and cases that we get a lot of appeals about. So that is why I chose those two topics. If we move to the next slide, so the legal basis of the medical standards, some of our medical standards are written based on law, the Road Traffic Act from 1988, and there's motor vehicle regulations from like within the last 15 years. But essentially, DVLA are acting on behalf of the Secretary of State for Transport. That is what we are doing when we are making licensing decisions, is we're essentially acting for the Secretary of State. We publish our medical standards. We publish it in the document Assessing Fitness to Drive. And the guidance within that is based on the advice of 6 expert panels that meet twice yearly for DVLA and give us advice on whether or not our standards seem to be reflective of the best medical evidence available. And they also have to take account of the prevailing legislation. Okay, so this is the part that is potentially a bit drier, but it's where it's decided that DVLA are the people that make the decisions about people's driving comes from the Road Traffic Act. That was written in 1988. And what that allows us to do is to investigate. I'm allowed to write to an individual and say, DVLA have been advised, or you have told us that you have a medical condition. We need further medical information from you. People are then authorised, given the choice of whether they agree, they authorise or consent to DVLA making inquiries. If they fail to agree to have their medical history investigated, DVLA ultimately have the potential power to revoke their driving licence for non-compliance with a reasonable inquiry. We issue licences, we do this all the time. If we also have the ability to refuse licenses if we believe that somebody doesn't meet the medical standards of fitness to drive. We can restrict licenses if people have a medical condition and they currently meet the medical standards, but we think that their condition could progress in future. What we can do is limit the duration of the license and make it subject to medical review, so that after a set period of time they'll come in for a review and we'll seek further medical information. prior to them getting their renewal. The motor vehicles legislation, it basically just names certain conditions that the law says that you have to meet. So if we could show the next part. We are trying to find individuals who have what the law defines as a relevant disability. And a relevant disability is either a prescribed disability, which you'll see listed below, or any medical condition likely to cause the driving of a vehicle to be a source of danger to the public. We're trying to get anyone who's a source of danger to not be driving, and people who are not a source of danger to drive if we possibly can. There are conditions that are named in the legislation. The visual standards for driving are set in law. I don't have discretion over that. The standards for people with epilepsy, also in law. Diabetes, severe mental disorder was the wording used in 1988. Liability to sudden attacks of giddiness or fainting, so the transient loss of consciousness that we were alluding to in Jared when he was speaking earlier, and also the persistent misuse of drugs or alcohol, whether or not it amounts to being alcohol dependent. Okay. So when you pass your driving test, you get your license until you're 70, unless DVLA are aware that you have a relevant medical condition. Then, if you meet the medical standards, you'll still get a license, but it might be restricted in duration. We take the basis of the driver, what they say, we take that to be factual. So if we ask you, have you had a seizure in the last year? They say no. Unless we have evidence to the contrary, we would go with what an individual says. HGV licenses, I don't know if you would ever be aware or be that interested to know, but you can basically get them from age 21. You can get them younger if you're in the military, but you get them from age 21 until 45. There's no further medical checks. And after 45, your license is issued on a 5-yearly basis until 65. And if you're older than 65, you can have an HGV license, but you have to reapply on an annual basis. Okay, and why do we do this, or what do we do this for? Well, there is more than 50 million people as of January 2024 that currently hold a UK driving licence. And there are 1.2 million people that hold Group 2 driving entitlement. As I'm sure you're all very much aware, there are significantly higher medical standards for Group 2 drivers. And this is because of things that you'll already be aware of. They spend more time driving. It is their occupation. And the size of the vehicle and the weight of the vehicle is significantly increased compared to a car. That is the basis for why the Group 2 medical standards are significantly higher. But you could subdivide that population. So age is not a barrier to driving in and of itself. If you don't have a medical condition, you can continue to drive. But I did a little subdivision of the numbers for you. So of the almost 52 million people that we have with a driving licence in the UK, yes, there's 6 million or more that are over 70, 1.8 million that are over 80, and there's 157,000 people over 90. But that's not just it. There are 681 individuals aged over 100 that currently have a driving licence in the UK. All right. We do not take people's licence away because of their age. They're welcome to reapply every 3 years over the age of 70. But these people, if you're seeing them in your general practice, if you're seeing them in surgery, consider, do they have a relevant medical condition? Is the combination of conditions that they have potentially relevant to driving? And potentially look to have these discussions with your patients. So a little bit more about where we get our information from. We get our information from the driver. If people have a relevant change in their medical condition, it is their legal responsibility to tell us, and people who are informed of that responsibility generally do. But it's not the only place we get information from. We get notified by the police if there is a road traffic collision and they feel that a medical condition might be relevant. We're asked to look into that for the police. We're sent health questionnaires and further information from healthcare professionals. It's not just GPs. We get notes, clinic notes. We'll look at independent reports. We commission independent reports. We commission testing, especially for Group 2 drivers with cardiac history. We request a lot of functional tests for those drivers. We send people for driving assessments. And where we have cases where we're not sure what to do, or where it isn't obviously clear whether the medical standards are met or not, we have the ability to get experts in the field to give us an expert opinion on individual cases should that be required. So that's what it's meant when it says panel opinion. So essentially, we get notified either by an individual or a third party. There's a new medical condition that we weren't aware of before. We commence a medical inquiry. We ultimately make a decision. And then at the end of the day, the driver either likes the decision, accepts it, and accepts their license, or if they object to it, or they are unhappy with the decision that we make, they can appeal to their local courts. In Scotland, it's the Sheriff Court, and in England and Wales, it's the Magistrates Court. Part of the job that the doctors do for DVLA is attending court for medical cases to explain the medical rationale for why the decision was made. So that is something that I do as part of my role for DVLA. Drivers medical at DVLA, you won't be surprised to hear that with an ageing population, the number of notifications to us of underlying medical conditions has significantly increased in recent years. And last year, there was just shy of 7,500,000 decisions that were made by the agency. You may or may not be reassured to know that of that number, 8.5% had their licence refused or revoked. So the vast majority of people that we investigate are able to drive, and we do give them licences, but if they do not meet the medical standards, in that 8.5% of cases, we do sometimes have to make the difficult decision to revoke the licence. We do that based on whether or not people meet the medical standards as published in our document assessing fitness to drive. The document, as I said previously, is either based on legislation that's in force currently in the UK, or it's based on advice of the expert panels. Now, at the moment, we have 6 panels that advise DVLA twice yearly. They have experts in the fields for diabetes, drugs and alcohol, psychiatry and mental health, neurology, vision, and cardiology. These specialists help us revise medical standards if they need to be updated, and they discuss with us complex cases when and if required. What we're really looking to do, though, is identify people who are at risk of a sudden and disabling event. The people with the transient loss of consciousness, again, that was mentioned earlier, they are a significant condition that we want to make sure that people who have an underlying liability to collapse are not currently driving. You have a significant more leeway for a Group 1 licence, that you can have anything up to a 20% likelihood of having a sudden and disabling event and still be allowed to have a driving licence. But if you're a Group 2 licence holder, that's 2% or less. Otherwise, you don't get your driving licence. And these statistics are factored into the medical standards as published. So you don't have to worry about, is it a 2% risk, is it a 20% risk? But it's why certain conditions you have to be off for 6 months, you have to be off for 12 months, you have to be off for potentially longer, okay? Group 2 drivers, that's another lovely picture of a crashed car. Unfortunately, Group 2 drivers are significantly more likely to be involved in fatal accidents. Again, it's the size and the weight of the vehicle and the number of hours that these people spend behind the wheel. So that is the reality that we face. Motorways, they're safer roads, but not all driving happens on motorways, and accidents can still happen on motorways, and fatalities also do occur there. So the type of road can be very influential on where the accidents occur or how common that accidents are likely to be. But whose responsibility is it anyway? Okay, I'm not going to spend a huge amount of time for this because I'd like to go into the more clinical aspects of the cases, but just to run through these slides with you. The driver, it is the driver's legal responsibility to tell DVLA if they have a relevant medical condition, but they have to be told that it's a relevant medical condition, and they have to understand that it is their responsibility to tell DVLA. So that's number one, the driver. It is their job to tell us. What is the role of a healthcare professional? Well, I would implore you to let your patients know that if they have a relevant medical condition, that you advise them that if you think it's likely to impact on driving, you tell them that. You advise them that it's their legal responsibility. If they've had a new diagnosis of multiple sclerosis or insulin-dependent diabetes, they do have to tell DVLA about that. It's your job, obviously, to look after the patients, to treat them, to manage them, and that is, in most terms, the most impact that you're going to have on a day-to-day basis in respect of their driving. And that's where someone like me takes over and I do the medical inquiry and I ultimately make the licensing decision on behalf of DVLA. But the queries come when someone cannot or will not notify DVLA. And these are the ones that we want you to discuss with us, discuss with your trustee advisors at the MDU and any other medical or defence organisation, but make yourself aware of the guidance. Okay, so the GMC's guidance was updated in 2017. It hasn't changed since then. The changes to good medical practice that have just recently come in haven't affected this at all. The confidentiality guidance was published in 2017. It was updated a bit in 2018. But the guidance in respect to what your responsibilities are in respect of information disclosure are readily available for you to see. So please do familiarise yourself with that. That's my only plea to everyone on this webinar today. It does stipulate within the guidance, on the next slide, I think I've just taken some, yeah, it's the same quotations that Jared showed you earlier, but the confidentiality guidance details what situations that you can consider disclosing information in the public interest, what you should do and how you should go about doing it. But where you have information to suggest that someone is unfit to drive, that is recognised as one of the situations in the guidance. So all I would ask is that you familiarise yourself with the times when you should disclose. You obviously can discuss this with your colleagues, discuss it with the MDU, or contact DVLA. So we used to have a telephone line, but at present, all inquiries to myself and my colleagues is via email contact initially. If you want to discuss the case, feel free to email MedAdvisor, and you could say that it would benefit from a discussion, and we can then email you back and arrange a suitable time to discuss a case. If you have the consent of the individual, you can give us their information, but you can discuss plenty of cases with us completely anonymously and not provide us with the information. So we're going to move on, and I've got some example cases for you. I need to give you the disclaimer, none of these cases are actually real, but they are all based on scenarios that regularly occur and that I would regularly see in the work that I do for DVLA. So if we go to the first case. So DVLA get information from anywhere. People can send in a clinic letter, people can call us, your neighbour can report you. Anyone can report you to the DVLA on the gov.uk website, via the telephone, or via, they can write us in a letter handwritten and it will get to us. So in February 2022, DVLA gets a notification of concern about somebody's neighbour. They're concerned about his memory, they've spoken to them, but they live near a school and they have ongoing concerns that his memory might not be good enough. So what do we do with this information? We write to the gentleman and say, DVLA are in receipt of a concern from a third party. We never disclose who the third party is, and we don't disclose the third party information. We say, do you have any medical conditions relevant to driving? He says, no, I'm fit and healthy. Declares no medical conditions, advises he does meet the visual acuity standards, and that's that. He tells us the name of his medical professional, doesn't object to us contacting them, so we request information from the GP and essentially say, does this gentleman have any confirmed diagnosis of cognitive impairment or any other medical conditions? GP says no, he's been seen recently, no evidence of cognitive impairment, nothing documented in the notes, and we're not aware of any other relevant medical conditions. So following that inquiry, you'll hopefully be unsurprised to know that we conclude at that point there's no evidence of any relevant medical condition, so the individual is allowed to retain their licence. Mr. T hasn't done anything wrong as far as we're aware. We don't know that he's got any kind of relevant medical condition after asking him, after asking his doctors, and so he can continue to drive. But that's not the end of the story for Mr. T, so we get a further notification for the same gentleman. We don't know exactly who it's from, but it appears to be from a relative of the gentleman. They feel his memory is getting worse. He refuses to admit that he has a problem. They've changed what he's allowed to do at home. He's not allowed to drive his grandchildren, and he's recently called the police saying someone has stolen his car. He says he refuses to see the GP, and they've tried to take his car keys, but he won't give it to them. So what do we do this time around? We still have to write to him. Okay, we still have to ask his permission to either look into his medical history, or if he doesn't give us this permission, we do have the ability to take his license away, like I said, for non-compliance with our inquiries. But he says, no, it's fine. I'm happy to give you information. I've got high blood pressure, nothing else. Despite it being a bit later in the year, he hasn't had to go to see the GP for the last year. So we know there's not going to be an updated information from the GP if we go out at that point with no further information and ask them to take medical information just from the records. So what we decide to do is write the GP a bespoke letter, and we say, look, terribly sorry to bother you. We asked you earlier in the year if this gentleman was known to have any medical condition, and you kindly told us no. What you weren't necessarily made aware of is that we have been told now by 2 members of the public that they have concerns about this gentleman's memory and that it impacts upon his ability to drive. Please could you examine this gentleman and let DVLA know if you consider that he has any evidence of cognitive impairment. Okay, so the GP comes back and says, actually, yes, 6 score is elevated. We're going to refer him to the local memory clinic. The GP gives additional information. They say, look, we'll refer him for a driving assessment, and that way we'll have a better idea of whether or not they're fit to drive. They make the referral for the driving assessment themselves. So we say, fine, that's wonderful. Please can you let us know when the driving assessment's been done? We'd love to see a copy of the report. And that all appears to be fine. But then the gentleman calls up DVLA and he says, actually, I've been out for a driving lesson with my friend. They say I'm an excellent driver. I don't need to go for a driving assessment. I'm not going to be going for that. And we didn't actually send the referral for the driving assessment. So what do we do? Well, in that kind of case, what I would do is I would write to him and say, actually, we have significant concerns. We want you to attend for a driving assessment. We, the DVLA, are now asking you to attend for the driving assessment, as we want to be assured that you can maintain safe control of the vehicle. We are going to make the assessment, and we're going to refer you. We'll pay for the assessment, but if you fail to attend the assessment, we will revoke your licence for non-compliance with our inquiries, and they specifically told that. So the gentleman does actually go to the driving assessment. There is demonstrable evidence of cognitive impairment on pre-drive testing, and the on-road drive is considered unsafe. So following our inquiries, we have now shown that we think he has cognitive impairment that is impacting on his ability to drive, and we revoke his licence. That's a decision that he would be free to appeal if he wanted to, but I think in my fictional case of Mr. T, he did not. Okay, so a high-risk offender, I don't know if you'll all be aware what a high-risk offender is. Basically, drivers with certain drink drive or drug drive offences can be coming into DVLA under a programme called the High Risk Offender Scheme, where we essentially have to do an examination of them. When they come back in, they've had their licence disqualified by the court, so they have no cover to drive, and they're applying to DVLA to get their licence back at the end of their period of disqualification. And we do a medical inquiry to make sure that the drink drive offence was not likely to be due to a medical condition, if that makes sense. I hope it does. Okay, so this example, it's a 29-year-old lady. She's applied following her disqualification. She's had 2 drink drive offences, both in 2020, and that is why she's considered a high-risk offender. Having a drink drive offence doesn't necessarily make you a high-risk offender. It's certain offences, and I will not bore you with the legalities of that. She says she doesn't have any medical condition. That's fine. We have to send her for a medical assessment, so we send her for an independent medical examination, and we also take bloods for carbohydrate deficient transferrin to try and get an idea of whether or not she's been drinking alcohol to excess in the 2 weeks prior to the blood test. Her examination is completely unremarkable, and her CDT result is fine. So we write to the GP and we say, does she have any relevant medical condition, especially in respect of alcohol or drug misuse? And the GP says, I'm terribly sorry, she's newly registered. We do not have her notes. I can tell you that she's not currently treated for any alcohol-related disorder, and she's not on any prescriptions of any medications like antabuse. So DVLA look at all the information that we have available, but given that she's told us she doesn't have a relevant medical condition, and we haven't been able to identify one from our inquiries, we're going to give her a full-time licence because I don't have any evidence to suggest that she's got an underlying medical condition. Okay. So the third case is on an individual who's had a previous seizure and they may or may not have an alcohol use disorder. Okay, so the scenario is the gentleman comes in and says, Mr. X, I had a seizure in February. He offers to surrender his driving licence. We say, thank you very much. No problem at all. The licence is surrendered. It's all very straightforward. Once his 6 months is up, he's free to reapply, and that's what he does. So he comes in with further medical information. He says he hasn't had any further seizures, so it's been more than 6 months since the last seizure. He provides us with a hospital discharge letter. He goes above and beyond the information that we'd actually required him to give. This mentions that he'd been drinking a bottle of wine per day. He'd been seen by the alcohol liaison team while he was in hospital. He didn't want further input. He tells DVLA that he's reduced his alcohol intake and he currently drinks 2 bottles of beer every night. So DVLA go out to the GP requesting further information. Again, we're looking for an underlying medical condition here. And the GP says there's a history of alcohol dependency and there's a history of alcohol misuse. The GP doesn't know at that stage whether either condition is controlled because they haven't seen them recently, and so the current alcohol intake is unknown. So at that stage, DVLA would refuse the application that he's made. The refusal would be on the basis of the fact that we agree there's not been a seizure within the last 6 months, so it's potential that he could have requalified on the basis of the seizure alone. However, we've been told he has alcohol dependency and his past alcohol intake was above the recommended limits and he continues to drink on a daily basis. So he cannot meet our published standards because they require him to be abstinent from alcohol. Okay, so as this story goes, he appeals this decision to the local magistrates court. When he appeals to the court, he provides further information to the court to try and explain his situation. And he states he was drinking heavily. around the time that he had the seizure. This followed a bereavement. It was for a short period of time. He states that he's managed to cut his alcohol intake down himself. He didn't require any kind of medically assisted detox, and he didn't require any other assistance from healthcare professionals. He's no prior drink drive offences. This gentleman is not an HRO. He's had a job for a long period of time, more than 20 years. His job is now at risk. And he says that he previously misused alcohol, but he is not and never has been dependent on alcohol. So what would we do in this situation? The difficulty DVLA has at that point with that case is that we've been told he's got alcohol dependency, which is one of the conditions that is listed in the legislation as being a relevant disability. So we've been told he's got a relevant disability. If he has a relevant disability, we have to kind of apply the medical standards as published. And as I say, for drivers with a history of alcohol dependency, he has to be abstinent to regain his licence. So where we're at, in conclusion, please don't assume anything. My main takeaway from when I did geriatric medicine and I used to do the movement disorder clinics was realising the amount of patients who continue to drive when I had maybe just assumed that they never got anywhere near the passenger seat, anywhere other than the passenger seat of a car. Do ask your patients if they drive. Do check if they drive professionally or if they just drive for social purposes. Please look at our guidance. It's updated regularly and it's available on the internet. You can see it at any time of day or night should you want to. Please do contact us if you have questions. There are lots of scenarios that don't obviously necessarily fit easily into one of our criteria, and we would be happy to go through a case scenario with you either on an anonymous basis, or if you have the consent of your patient, you can give us their information and we can look at their case. But again, we would need their consent and we'll need to be assured of that. Consider whether you should be telling your patient whether they should not drive while we do inquiries. Consider whether you should refer for a driving assessment, we should refer for a driving assessment. Just have a think about it. Please give us as much detail as you can when you are contacting us. It'll make our decisions a lot more accurate. And please do check out the GMC guidance on confidentiality and information disclosure to the DVLA. Thank you very much.
Claire, thank you very much. Ed, are you online? I imagine there's been a number of questions come in. Are you able to share any with us?
I don't think I've ever seen as many questions, Claire. So.
I thought that might happen. So just to clarify, when there's a lot of questions, we can't answer them all. We will go through them all. Ed and I will go through them tomorrow. We may try and speak to Claire about some of them afterwards. But remember that DVLA email I've started giving out on the advice lines. I told Claire before we started, you know, there may be a sort of a rush of people to ask questions off the DVLA as a result of this. But Ed, over to you.
A couple of very quick ones, which I thought were interesting. One person asked about licensing for mobility scooters, and if that's something which the DVLA gets involved in. And it's a different question, but on the same note, somebody who doesn't have a UK driving license, but is driving in the UK on an international license or a license from another country. What does the DVLA do there, or how can the DVLA help?
Excellent question.
We have had the mobility scooter one before, Ed, I think. I know that we've dealt with something similar to that in the department, with somebody very old driving on a motorway.
So I'm pretty sure with respect to the mobility scooters, it's whether or not it's a vehicle that's licensed to be on road or not. But honestly, I don't want to tell anyone lies on this presentation, so I can look into that for you, but I don't want to give you misinformation. In respect of your international driving license, they're allowed to drive within the UK, but if they have a relevant medical condition when they're here, we should be advised, because they can't, if we revoke their license, for example, in the United Kingdom, they can't use that. We obviously used to be part of the EU and it would be revoked in all parts of that, but that's now not the case. But if they've had their license revoked, that is something that would be relevant to the licensing authority here. So I would have thought that we need to be informed. but the logistics of how and when we would actually do that would be a DVLA problem. So I would say that if you've got a patient who's got a medical condition, DVLA should be informed, and then the actual logistics of who does what where behind the scenes would be an us problem, not a you problem.
Yeah. Thank you.
Perfect. This is a question which I think we get more frequently, or which doctors ask us when they've sought advice about notifying the DVLA, and it's, how does the doctor know that the DVLA has received a notification from the patient? And how do they know that something has been dealt with appropriately or not, as the case may be?
That's a far trickier one, because as a default, well, if you've had a questionnaire from us, you know that someone's told us and that we're at least looking into it. If we've written you a letter, it's obvious. But you won't always know, because DVLA used to share licensing decisions with the doctors, but it's seen to be we don't have the authority to do that under like data protection and or sharing of information. So we don't routinely share licensing decisions with doctors, but we can where we consider it to be, again, in the wider public interest. So you won't routinely be informed of the outcome of inquiries. I would encourage you to have the dialogue with your patient and say, look, I'm very worried about your license. I need to know that you've told DVLA. What can you show me to show that they should have some sort of paperwork. They should have some sort of paper trail to be able to show you that I called them, they then sent me this questionnaire, I've completed it, you've been sent this other information. Or when we've done a licensing decision for them to be able to keep their license or not, we will absolutely always write to the driver. So if we've said to them they can keep their license, they can say, ta-da, they said I can keep my license. If they can't provide you with that, anyone can check their licensing status online at gov.uk. So you could have a discussion where you ask them to share, they would need to share a code with you. So you would need to do it actually during a consultation for them to show you that they still have a valid license. But that's a more complex scenario.
A couple of sort of grey area ones. One was, when should patients be informed, or sorry, advised to inform the DVLA if, for example, a GP suspects that they may have a relevant diagnosis, but it hasn't yet been confirmed? So again, sleep apnea might be one where somebody has some symptoms and has been referred on for proper investigation of that. Should the GP inform them to notify the DVLA at that stage, or should they wait for the diagnosis to be made?
There's not a hard and fast answer to those kind of things. If you suspect the person had a seizure the day before, you should be telling them to not drive. It's more important that you tell them to not drive if you have concerns about their driving than it is that DVLA be informed on that day. Because then if they have full insight into their condition, they should be able to follow your instruction, which was do not drive until we've had further investigation. DVLA do need to be informed with certain conditions regardless. So if it's a new diagnosis of sleep apnea that's confirmed, we will need to know about that if they've got excessive sleepiness, if they've got symptoms relevant to driving. But I would say that the more important thing initially when you're under investigation is that you give advice to them about driving, whether they should drive or whether they shouldn't. And that ultimately we will need to be informed, but you can argue the toss about whether you tell us that day or whether it's actually been confirmed. But what will always need to be told is, I don't think it's safe for you to drive at the moment. Please can you wait until we get the results of these tests and then we'll take it from there.
Yeah.
Okay, so it would be the functional impact of the condition on the person. So the sleep apnea was one that I brought up just before this because I had a call about sleep apnea on Friday that made me go and look up sleep apnea guidance specifically, and it's something I hadn't looked at for a number of years. But I think the discussion was that the impact of the patient on the patient specifically was the most relevant thing.
Yeah, sleep apnea can be quite a difficult one because before the call, Jerry gave me a scenario whereby I think the person was having apneas overnight, but not really complaining of sleepiness during the day. And we're looking at people who are having excessive sleepiness during the day and when they're going to be behind the wheel. An apneic event at night doesn't in and of itself concern a practitioner working for the DVLA, but if they were also having little catnaps when they were at the traffic lights, if they were hitting the rumble strips when they were driving at night and they couldn't remember what had happened, these are all far more suggestive that they're having a significant functional impact of it. So again, when you're not sure, there's very little danger in telling someone not to drive while you are investigating or looking into something, while you're taking advice from the DVLA, while you're taking advice from the sleep clinic, what you should do. When a condition is confirmed, it becomes their responsibility to tell us. And when they're under investigation, there's the subtleties. I can't say always yes or always no, but yeah.
Okay, thank you.
One theme that came up from a number of different doctors working with learning disability patients and also with older patients is that they think that the guidance can be a bit opaque with regards to either autism or ADHD or patients with mild cognitive impairment. I suppose that the thing to do with that is if there's any doubt about it, either to contact you for a discussion about the patient at the DVLA or to tell the patient to notify the DVLA, because they're safer to do that than to not do that. And the DVLA can then make a decision about whether the license should be retained or not. It's better to do that than to leave them in doubt.
Well, because then no one can say that either the driver can't be accused that they haven't fully shared that information, because there could be implications for their insurance and all these other things. But in respect of the cognitive impairment, it's a difficult one. You can have cognitive impairment following a traumatic brain injury. You can have cognitive impairment, obviously age-related. You can have cognitive impairment that's been diagnosed as mild cognitive impairment, one that's likely to progress, and plenty of mild cognitive impairment doesn't progress to dementia-like illnesses. So there is, it's very difficult to have hard and fast in every situation you should do X. Guidance, and I suspect that's probably the problem that a lot of people are finding when they're trying to practically apply it to an individual situation. So like you said, Ed, when they have concerns, they can raise it with us if they want to talk through a case anonymously or not. In respect of ADHD, if they're applying for their provisional license, we tend to take the line that unless you have very significant concerns, or if you think it is absolutely going to impact upon their driving, we tend to try and allow the DVSA test, like actually being able to pass the driving test, to be a kind of arbiter of showing that there is a certain level of control. So I don't want everyone with ADHD to feel that they have to notify DVLA, because they absolutely don't. And if they've previously passed a driving test and had that diagnosis, they do not have to tell us, because the implication is that by being able to pass a test where they've had to learn the rules of the road and obey all the signs to be able to pass a test the same way any of us might have done, they've met the standards. But where you are unsure, absolutely contact us.
Claire, I think what was very interesting on the stats that you showed was that you might investigate or look at a lot of drivers over the course of a year, but most of them will retain their ability to drive. And that's really important, because often when we're talking on the advice line, the major concern is the serious impact it's going to have on that person in terms of their ability to drive. And it sounds like it's not as common as I think, certainly as I thought it might be. And the other thing which is striking is the fact you keep the case open and collate information over time. And if more information is disclosed to you, then you may go back and look at things in a different way, which is also helpful. Thank you for that. Ed, anything else? Yeah, I know that it's very hard to collate and there's lots of questions going on. I'm really grateful that you're doing this for us. Thank you.
I should apologise. I mean, I've tried to answer some as we've gone along directly to the people who put the questions in. I should apologise to them for the egregious typing errors, because I was trying to do it so quickly. One which did come up, which kind of touches on what we've said before, is that you at the DVLA will send out questionnaires to doctors if they think that they've got information which is relevant but which isn't necessarily captured by the questionnaire or the tick box or the small area where they've got some free text. Are you happy to accept sort of a cover letter or anything else with additional information?
Always want information. I'll take any information that you want to give me. If you think it's relevant, I want to see it. Absolutely, please.
I suspect I know the answer to this one, but it's one which we certainly get from time to time. Is a patient makes a disclosure to a doctor about drug use or alcohol use, or maybe that they've had some sort of seizure, and when the doctor tells them that they shouldn't drive and shouldn't inform the DVLA, suddenly the history changes and they retract. I'm assuming that this is a bit like university challenge. You have to accept the first answer.
With those kind of scenarios, we tend to go with the contemporaneous records of the event. Like if they turned up at A&E and it's documented that they had a seizure, it was witnessed in the A&E department or it was witnessed in the ambulance, we'll go with the contemporaneous record. If the history changes a month after the fact, with the greatest respect, we can only go on what we have factually available to us. So we do tend to go with the first recorded, the most contemporaneous record of the event that's held is what we tend to go with. If a diagnosis is truly revised after the fact, we also accept that diagnosis change. You know, we can modify our licensing decisions based on new information as it emerges, but I would tend to go with the first account.
I mean, there were a huge number of questions about sort of various quite specific clinical scenarios, and you know, I think I would encourage those doctors who put those questions to go back to your guidance on the DVLA website and look at the medical standards publication, because I think a lot of those questions will be answered if you carefully look at that. One of the sort of the questions which I've just lost it.
Yeah. Are you ready, Ed? I've got one
yep,
to do with the number. Can I ask Claire, of your decisions to remove a license, revoke a license from a driver, how many are subsequently reversed by the court? What percentage in a year would you think?
Oh, reversed by I don't have the figures for that, but off the top of my head, very few.
Yeah, that's helpful. Okay, Ed.
Yeah, I think there may be time for one more, possibly, maybe more than that. But I apologise if you answered this in the talk, because you were talking about patients having driving assessments. Can doctors refer patients for driving assessments, and how do they do that? Is that through the email?
No, so DVLA don't actually specifically do the driving assessments. It's Forum or Driving Mobility that do them in the UK, and how they do it would depend on their local NHS service level agreement that they might have with them. So a driver can refer themselves, they would pay for it. A healthcare professional can do it depending on the local arrangements in that area, or we can do it. And if we refer them for it, we pay for it. If a GP refers for it, I imagine not particularly the practice, you know, but it would be funded by the local NHS, and if the driver goes themselves, they are paying for it. So there's multiple ways in which a driving assessment can be organised.
I think that's probably us, Ed. We're approaching 8 o'clock. I think that this is one of those presentations that we could easily leave running for another half hour, and having poor Claire fending off questions for another half hour. But Ed and I will go through all the questions, and I may come back to you, Claire. But thank you very much for coming and speaking to us this evening. It's been really helpful. As I said, it's always a problem for our members, and it's really helpful to get a face and to get a doctor from the DVLA coming and speaking to us in language that even I can understand. So thank you very much for that. Do remember to give us some feedback as well. You'll get your CPD certificates, I think, once the feedback has been done. And please look out for our upcoming webinars. We've got a whole selection of them coming up over the course of the next few months. And if it's the DVLA is a ongoing issue, I'm sure that I'll be back on the phone to Claire, asking her to come back and talk to us again. So thank you so much for joining us this evening. Have a nice night, and goodbye.
Thank you.